of that commission. I also got the Hansard from Parliament to see what the debates were, why each member in that commission is there. Why do we have lay people? Why do we have lawyers there? Why do we have a representative of the judiciary? Why do we have public service? And I was intrigued by a provision in Article 146 that says the Chief Justice, Principal Judge, Chief Registrar shall not be members, and say why. So I wanted to find out. So I found out a lot about the composition of that body and its relevance as far as the judiciary is concerned, how they dispense justice in their own right as a tribunal for judicial officers, how they appoint judges. And also, you remember from my campaigns, I used to always post almost cases. I dug into cases that discussed the role of the Judicial Service Commission, the role of the president in appointing judges. What is the role of Parliament? What's the role of public? So I can say that I learned a lot, but I also learned that we need to understand that the quality of justice depends heavily on how the judiciary is built, not how judgments actually written or cases are decided. We often tend to focus on judgments, but the real foundation of how the judiciary is built is quite critical, and that body is actually very important because it's the midwife of judges. And I saw that it has a lot of limitations that are structurally embedded in how the law that governs it looks like, the regulations that they are implementing, how they look like. And I was able also to look at the propriety of their powers to make rules and regulations under that act vis-a-vis what the Constitution says, and actually came up with the idea that I think from what I see, the regulations, the way they look like, it didn't look like, yeah, I would be a member there, but I didn't look like I would make a serious contribution, because I saw that the regulations have been structured in such a way that the Law Society members can fill spaces there, but may not necessarily, have a voice counting in the whole process, because this whole idea of having a committee that searches and interviews and sends names to the broader commission membership kind of prepares the meal, and we also wait to eat it. So we don't have a choice on what we want to eat. We don't have a choice on who makes it to the short list. We are not on that committee, and I said no. I think it's going to drain me so much to be there, yet I don't see much contribution as the regulations look like. So I decided to get out of the race, not because I was not interested, but I thought that structurally the way the whole institution is structured does not give you much leverage as the bar to really add a voice on who becomes judge, who becomes promoted, and who becomes appointed.
Thank you. Thank you, Dennis, for that. If you're just joining us, welcome to Judicial Service Conversations. We're having a conversation about closer to the people, magistrates, courts, and the future of justice. And Dennis has just taken us through his inspiration and the structure. I want to just dig in a bit there. You talked about, since you have studied the history, maybe you can give us the brief understanding. So why isn't the Chief Justice, the Principal Judge, and the Deputy Chief Justice, why aren't they members of the commission?
So historically, I don't know, the first Judicial Service Commission has been here actually since the first Constitution. And historically, actually, the Chief Justice was its chair.
Yes.
And it had very few members.
Mm.
Chief Justice,
the
I think the
Attorney
Prime
General.
Minister, the Attorney General,
Yes.
and
That was about it.
that's about it, yeah.
Mm.
And with the heavy hand of the President
Mm.
in appointing what we call, how do you pronounce that word? Queen judges.
Queen.
I remember when I was a paralegal, I used to go and all the time I'm reading Justice Mukanza's on Justice Mukanza's door. He's the only one who had that word on his door. And I was like, what does this mean? But look, I think it's something to do like an acting judge or something.
Yes.
Yeah, so the President used to appoint them, and obviously they will be confirmed. So it evolved over time, but in the 1995 Constitution, I think there was this wave of independence of the judiciary. And independence of the judiciary starts with actually the appointing body. The body that not side appoints, but the body that actually processes the candidates who become appointed, or the body that appoints. I think you even saw this prominently featuring in the Kabazi-Guruka case. How are these people appointed, that kind of stuff. So the independence of the judiciary meant that also you needed an independent Judicial Service Commission. Independent Judicial Service Commission in all aspects, not only about appointing judges, but also or judicial officers. Let's not focus on judges alone, because they appoint judicial officers. And judicial officer, the term is quite wide. They focus, it's not about independence in appointing judges, but also independence in disciplining them, independence in promoting them, and all that kind of stuff. So from my reading in the Hansard and my Lord Chief Justice Emeritus Sodoki report, it was believed, actually the first clause that was drafted by my Lord, the late Justice Mulenga and his committee, was for the Chief Justice to chair the Judicial Service Commission, as it was before. But I think there was a concern. And the concern was that the Chief Justice, I think, is an administrator. And it was anticipated, although it didn't turn out to be the way it was anticipated, and that's the problem I have with the current regulations, the way they are structured, that the complaints against judicial officers would be lodged with their immediate supervisors. The Chief Justice, you would lodge complaints against the Supreme Court judges before the Chief Justice. And the principal judge, you would lodge complaints against the judges of the High Court with the principal judge. You would lodge complaints against magistrates or lower bench judicial officers with the chief registrar, and then the deputy chief justice, of course. So they would in a way be complainants, and they would not now come and sit in their own cause. Although, of course, they would also initiate complaints on their own. So that's one of the reasons why they said these three will not be. But they allow one judge, and we increasingly see 3 judges now, because what is happening is that the chairperson is a judge, the deputy chairperson is also a judge. So the imbalance has already been distorted. Because I think framers of the Constitution wanted a balanced Judicial Service Commission. 1 representative of the judiciary, 2 members of the bar, senior advocates, members of the public, because I think the idea is that the public should have a say in who should become a judge. And a Public Service Commission comes there to bring the expertise in interviewing and human resource and what have you. The Attorney General is there to actually bring the voice of the President, the voice of the executive to that commission, to avoid a situation where they have processed a candidate and the President rejects them. The President should be able to exercise to voice his concerns through the Attorney General, and the Attorney General should be able to bring these concerns to the candidate, and the candidate is supposed to to actually have to be heard before he's rejected. But we see things being done differently. But that is the reason why you don't have the Chief Justice, the Deputy Chief Justice, Principal Judge, Chief Registrar as members. And also, one of the reasons the Chief Justice is not a chairperson as it used to be, because the chairperson is supposed to be a full-time job.
Yes.
That is why even they say you will not be the chairperson is a full-time job, and a person shall not be engaged in private practice.
Yes.
Which gives me an impression that maybe they actually thought it should be a private practitioner who should be the chairperson of that Judicial Service Commission. But no problem about that. My personal view, I think that any could be, and I believe that the fairness demands that if the chairperson is a judge, at least the vice chairperson should be from the bar, so that we still bring back the balance of the framers that they intended. Yeah.
Thank you. I agree with you. In fact, I think that there's a certain allergy that there's an allergy that certain echelons of the administration of justice in this country have developed for the bar. When they see lawyers, they get a bit of a rush. So the idea seems to be to keep locking out the lawyers, and you've talked about the regulations which have locked out lawyers. But maybe so you then move to the judicial. You leave the race, and you are then appointed by the Law Society onto what is called the Judicial Affairs Committee. And this Judicial Affairs Committee seems to be a committee that is addressing members' concerns, maybe you'll correct me if I'm wrong, with the judiciary. And I think what we want to know is, just tell us about what is the Judicial Affairs Committee, what do you do? I know that all Law Society committees, this is purely voluntary work. You are entirely unpaid, and you are volunteering to be on a members committee that is talking about judicial affairs. So what kind of judicial affairs do you concern yourselves with, and how is that committee formed? Was it always there? And
I think having been a very vibrant, I hear, candidate in the race, when I said I'm not going to be involved anymore, the president of Law Society, the vice president, tried to persuade me not to get out of the race, because they thought it was good for competition. Not that they supported that I should become the representative, but I think I'd brought a lot of rigor to the campaigns because of what I was trying to summarize and educate members on, specifically focusing on matters of the judiciary, particularly my obsession with the Latimer House principles that have a lot to say about the independence of judiciary, executive, parliament, and how those three arms can mutually support each other without necessarily compromising the independence of
maybe
each
just
other.
briefly there, just tell us, just because many people are listening and they've never heard of Latimer House. So what are Latimer House principles, maybe, before you get into the...
I think Latimer House principles are just a set of rules or principles that were developed by the Commonwealth member states, comprised of judges, ministers, parliamentarians, to talk about how the independence of these three arms of government can be strengthened, can be enhanced, and sure that Parliament doesn't do the work of the judiciary, judiciary doesn't do the work of Parliament, executive does not encroach on the work of the Parliament, and so forth. But at the same time, not leaving either of these arms unchecked. So it's a huge task that those member states undertook and came up with those principles and they sat at Latimer House in Birmingham. That's why they call them Latimer House principles. But because they were developed at a very generic level and probably viewed as so much Western centric, I think the African countries also came back to Africa and they sat in Nairobi, Kenya, to come up with what we call the Nairobi Action Plan, that kind of trying to appoint judges or whatever, but we focus on three things, and they could evolve because it's a new committee, and every time circumstances arise, we learn that probably we need to add that to our mandate, which is ever expanding. Hope it doesn't become amorphous. So we first focus on court structure, making sure that the reforms that are being proposed actually improve justice delivery. That is number one. And that's why you saw that we are so involved in the proposals to amend the Magistrate Courts Act, because that now talks about the structure of the courts. The second thing or aspect is judicial independence. We resist provisions that allow administrative interference with adjudication. We resist them strongly, which we review laws that we think impinge on the administration of justice, independence of the judiciary, fair trial, speedy trial, etc. And third, we strongly focus on judicial appointments. How? Judicial appointments and accountability through ongoing work with other peer committees, with international donors, international bar associations, by picking lessons, by reviewing what other countries are doing, and trying to come up with a position of the Law Society which we think our members, when they go to the Judicial Service Commission, will be talking about. Because previously we've had members go there but without a position of the Law Society. Somebody goes there, number one, we haven't voted them, number two, we have not given them any terms of reference, they are not accountable to us. Now we think that the people who will be appointed will have a concrete, not that we are going to compromise, they have also their own heads, but at least the Law Society must have also a position on some of these things. But there are also the judicial appointments. Also, we try to fight for the diversification of the bench, avoid what we call judicial replication, where we see the judiciary replicating itself by only recruiting from within, and therefore replicating the same judiciary. If it's lazy, it will be lazy forever and forever. Amen. If it is lacking in a certain breadth of skill or expertise, it will be like that. So we're going to focus so much on ensuring diversification, and the diversification in the real true sense of the word, because I think what I've seen most of the time when we talk about diversification, people confuse it with gender. They say diversity means more women and less men. The term is gender and diversity. Diversity is to do with some academia, some private practitioner,
broad profession, some
people from DPP, some from MDAs, some from private practice, others from the judiciary. And we appreciate actually, and even corporate world, Justice Chile, we came from corporate world, and what a brain we have got in the Court of Appeal. We acknowledge that one of the major retention tools the judiciary uses is promotion. So it is not really, we're not entirely objecting to recruiting from within, because they have to promote these people and encourage. If you have promotion, then you have attraction, you attract people because there is a progression. But we think that it cannot be the way they are doing it, where you find that the entire quarter. I remember I read something some during the campaigns where they said this time all the magistrates were just promoted. We think that is not good. It's not good for the public. The public is entitled to a diverse bench. We think that we can come up with the means of having a quota for the judiciary, but also at the same time promote diversity. So we think that we are not an antagonistic committee. We are here to actually provide good suggestions and accountability, to hold the judiciary to account why they delay to decide cases. We appreciate the backlog, but we also are aware that there are many times our members go to court and the judge has not come, the magistrate is not there. There are many also other indicators that backlog is just one of the problems, but there are also other structural problems, and we intend to achieve this through cordial engagement with the judiciary to see how we can improve. So that is just about it, this committee, and the mandate keeps evolving as circumstances demand.
Okay, if you're just joining us, welcome. We have a fantastic guest today, Mr. Dennis Kusasira, and I think it's interesting hearing about the whole idea of the committee is to push to make sure that the issues members have with the judiciary are well addressed, including recruitment. You know, many members of the Law Society really and truly want to join the judiciary. Very many, actually. A large number of members want to join the judiciary. So it's good to have a committee that is pushing to make sure that there's fairness in recruitment. There's a quota for our members. I mean, it's really at the front line of fighting for members' issues, especially at a time when I think there's a little bit of worry about, not worry, but there's a little bit of concern from the public sector and the judiciary about the bar, and there seems to be this strictness. I mean, you've seen maybe we need a law council members affairs committee. You've seen some of the strict requirements for firms. We've seen a lot more regulation coming on 2 lawyers and yet less space. So I think it's good to really have a place where we can converse and the young lawyers, the Dear Young Lawyers series. Of course, as you know, they formed it together, but one is the chief executive and the other is the founder. So they share power like that. It's not clear who is whose boss. But also Joy has been very active in the communication space for lawyers' issues. I think I've recently seen her hosting R&B Live. So she's been very active in that space, and I think Joy is going to help grill you for for a question or two. So over to you, Joy.
Thank you. Thank you for that. Thank you for that, and Mr. Dennis Kusasira, it's a pleasure to have you here tonight. Thank you for sparing your time and coming to talk to us. And for the people that are listening, we want to appreciate you. We're discussing closer to the people, magistrates' courts and the future of justice. And thankfully, as Mr. Dennis was speaking, he talked about the public and the people. And I want to drive us to that because among the listeners that we have a mix. There are lawyers, and then there's other members of the public, other professions. So I want us to turn to the Magistrate Courts Amendment Bill 2026, and this time round it's going to be for the Omuntu wa bulijjo, if I might say that. It's not Omuntu wa wansi this time round, but Omuntu wa bulijjo. When I look through it, the bill's objective is to amend the Act to increase the pecuniary jurisdiction of magistrates' courts, to enhance their powers to impose higher fines, abolish the position of magistrate grade 2, provide for the designation of magisterial areas, provide for transitional provisions and related matters. And so, Mr. Dennis, at a fundamental level, if you could come in, why do you think this bill matters to the public or to someone who is listening in right now? Over to you.
Just wait. Just to be clear, the pecuniary jurisdiction, for those who don't
explain it.
Yes, please help us explain pecuniary jurisdiction. What are the other objectives? I think you should help us explain what these things mean, because I'm seeing that a large number of people who are listening may be struggling with those concepts.
Okay. So we saw the pecuniary jurisdiction of magistrate courts, and then the powers, maybe a little bit of what powers to be imposed, or the higher fines in there, and then the position, I think that comes in there together. And when they say designation of magisterial areas, what does that mean? And then the transitional provisions as well. So just a breakdown of that and why it should matter to the public and someone listening.
Thank you very much. So I think our listeners will appreciate. You will appreciate that they may even not know what a magistrate court is. But in my early days, I also did some teaching, so I can quickly impart knowledge. We have our hierarchy of courts in Uganda. The highest is the Supreme Court. Second highest is Court of Appeal. And paradoxically, the High Court is lower than the two. Yet it's the High Court. And then below the High Court, you have got magistrate courts. And
it is high, but it is not supreme.
It is not supreme, but yes, so it's a High Court. And I think previously we never actually had the Court of Appeal. We also never had the Supreme Court. So that's why we have High Court. And the Supreme Court was just created, I think, somewhere in the middle between, I think, 1980 something. And then the Court of Appeal, of course, and the Constitutional Court came later. But magistrate courts are those courts that are so littered all over the country. And they have had previously, I remember those days when I was a paralegal, I went to a court called the Magistrate Court of Kayunga, sitting at Nachifuma. And it had a grade 2 magistrate. Now, those were so close to the people. So you have grade 2. Actually, we used to have grade 3. They used to call them lay magistrate. Grade 3 and grade 2. Diploma holders, holders of diploma in law, who become magistrates, grade 3. Do you know that we had some judges who were magistrate grade 3 and rose through the rank? I think one of them is Justice Muchibi. I need to remind you, one of them, Justice Simpaji. So, magistrate courts are by far the most littered courts all over the country. Even by head count, we have more judicial officers in magistrates than judges. So, magistrate courts, in my view, are where most Ugandans actually experience justice. So, when you talk about a magistrate courts Act Amendment Bill, as the Judicial Affairs Committee of the Uganda Law Society, we take very keen interest in that, because that is where most Ugandans actually experience justice. It's actually the entry point. So that's why that bill is so important. And if that bill is not properly done, it can actually cause more serious problems that we already have than the problems we already have. So that's why we took very keen interest in it, and that's its importance. That if I give you the statistics, I was reading that according to what is it, the performance data reported, is it financial year 2022-2023 financial data, I think by UBOS, recorded the highest disposal of cases by magistrates grade 1. 134 583 cases.
That's 134,000 cases.
134,000
disposed.
Highest disposed. We are not talking about backlog, but they also sit just below the judges of the High Court in backlog. You can imagine, chief magistrates 35,108. And then when they talked about the caseload, the National Court Census found that after the High Court, the heaviest concentration of pending caseload and backlog are the chief magistrates courts and magistrates grade 1. Judicial officer to pending cases ratio in magistrate courts was 1 to 267.
So one magistrate here has 267 cases. That's not bad.
For chief magistrate. And for magistrate grade 1 is 1 to 210. So what am I saying?
Do you have the numbers for High Court?
The High Court, no, I don't have the numbers, but you can, somebody can check as we are going on the course, the National Court Census 2025. You will see the data is all there. So anything to do with the magistrate courts, any law that talks about magistrate courts is of great interest to us as the Uganda Law Society, great interest to us, the Judicial Affairs Committee, because it touches everyday reality of how citizens interact with the judicial system. Yes.
Thank you very much for that, and the data as well makes it weighty. We'll definitely check it up. If you could, if I could take you back to just clear on the pecuniary bit, the jurisdiction.
Oh yeah, you asked me also about what the bill is trying to do as far as jurisdiction is concerned, and our people may not know even what jurisdiction is, and we're not going to bore them with a legal definition. Jurisdiction is the power to do anything. Do you have the power? Like if you go to an office to ask for a job and you find a sweeper and you narrate all your problems and you say, I really need a job, and the sweeper listens to you and says, for sure you really need a job. And she's going to conclude by saying that, unfortunately, I am also just a sweeper. I'm not the one. How I wish
I could give you the job.
So the sweeper has no power to give you a job. So jurisdiction is that power a judicial officer has to decide the case. And for the High Court, it's unlimited. They can decide any case. For the Court of Appeal, it is only, you go there on appeal. For the Supreme Court, you go there on appeal also from the decision of the Court of Appeal, except if you are contesting a presidential election, then they have their original jurisdiction, the Supreme Court, And also if the Constitutional Court, the Court of Appeal is sitting as a constitutional court, they have also original jurisdiction. But magistrates,
you can sue there directly.
you can go there direct,
You can go there directly.
in the constitutional petition. Direct without, and there you're not going to the Court of Appeal anyway. You're going to the Constitutional Court. In other jurisdictions, actually, the High Court doubles as the Constitutional Court, but ours is a different. Yeah, and it used to be the case here, actually. For magistrate courts, they are uniquely structured. They have what we call territorial jurisdiction. Territory. Magistrate Court of Kayunga sitting at Nachifuma. And the Chief Justice, it has been the minister until now, when this bill is going to reverse it, the Minister of Justice would designate, demarcate magisterial areas. And they say, for example, if you have a matter in Rubaga, Kasubi, Namongona, Nakulabye, but most likely you're going to file your matter in Mengo Magistrate Court. If you have a matter in Luzira, Golobi, whatever, you are going to go to Nakawa magisterial area. So if you file right now, the law, what it says, if you file your case in Mengo when you're supposed to have filed it in Nakawa, it will be dismissed, because where you took it, they have no power to decide that case. The only thing they can do, dismiss it. And sometimes also these territories can be fluid. How do you know that now you are in this territorial jurisdiction or not? Some people, the bedroom can be in the magisterial, the house which you are fighting over.
Yes.
Or the tenant was not pay. If you have your muzigo, a train of them, some of them can be located in the Magistrate Court of Mengo, and others are in Naweru. So those complications are there. So the territorial jurisdiction. Pecuniary is the money, subject matter. Subject matter also is not necessarily pecuniary, but pecuniary means the worth of the claim that you have brought. Say it's a debt. I lent you my money and you haven't paid me, and I want to take you to court.
You can see someone who lent me.
Yes.
On the chart.
And the money is 100 million. So currently, the magistrate, the highest case that can be had by magistrate court is 50 million, and that by the chief magistrate. So you can't take there your case of 100 million. So over time, and then I think the magistrate grade 1 is 25 million. Now over time, and I think this was introduced. It used to be less. It used to be 5 million.
5 million, yes.
5 for donkey years. It used to be 5 million, and it was changed, I think, in 2017 to what it is today. But you can imagine, what can 50 million buy today vis-a-vis then? A plot of land in Kira, 50 by 100. The last I checked is at now 250 million. Can you imagine that if you have a 200 by 100 by 50, 100 by 50 size, it's, you know, an acre is 100 decimals, an acre.
Yes.
Half an acre is 50.
Yes.
Quarter is 25.
Yes.
Now 12.2 is half of a quarter.
It's an eighth.
Yes. I'm not very good at math, as
Then
many
you-
lawyers are not. I only know one who is, and I think it's President Semakad is one who is very good at mathematics. But look, imagine that minute plot. If you have a dispute, as we stand today, you have to go to the High Court. You have to go to the High Court.
To the land division there.
Land division.
And wait for 10 years.
And wait for 10 years. So what is proposing is to increase the jurisdiction of magistrate courts, the pecuniary, the more value worth of a case the magistrate can handle, to just 100 million. And I'm saying the man with the plot in Kira will still have to go to the High Court. That is not good enough. And we are proposing that it should be actually more than that. And we did a comparative analysis, what is happening in jurisdictions close to us. I think in Kenya, the chief magistrate can actually handle a matter of 600 million.
Oh.
Now, and what I'm telling you in Kenya happened in 2015, I think.
As we were changing.
As we were changing, we are going to 50. They are, for them, they are
600.
they were at 600 equivalent of Uganda shillings. So we've proposed that no, it should be higher than that. It should be 300 million at least for a chief magistrate. And we have also proposed that the rank that we should have bands or ranks of magistrates. I know it's probably one of the issues you said you wanted to tackle. I don't know whether I can talk about it now. I wait when it comes. But it is that currently in black letter law, you have chief magistrate and magistrate grade 1 and magistrate grade 2. The judiciary, the administration of the Judiciary Act, which is the law enacted under Article 150 of the Constitution to provide for the structure of the judiciary, does not recognize the office of magistrate grade 2. So it has been phased out, and the bill is saying all clauses that are talking about magistrate grade 2 should be amended accordingly by deletion, and then remain only with the chief magistrate and magistrate, just those two. That is the black letter law as it stands, law and statute. But in practice, if you go,
We have principles.
these people have got bands.
Yes. Principal.
You have the chief magistrate, you have the senior principal magistrate, principal magistrate, senior magistrate, magistrate grade 1.
So they're structured like the DPP.
They are structured like that, and rightly so in my view. Because also when I did a comparative study, I saw that in the East African region, Kenya has the same thing, Tanzania has the same thing, and I think for good reasons. How does it matter? Somebody may say we're defending titles, why defend titles and ranks? If you have a chief magistrate and magistrate, how do you allocate cases? How do you allocate cases according to complexity and level of experience? We think that if you have those indicators of who is senior to who, the person who is manning the chief magistrate court, the chief magistrate, can easily allocate complex cases to a senior magistrate without necessarily going to check when they entered the judiciary, when they were born.
Should the same experiment be done in the High Court? You have, you may have someone who has come in day one and someone who has been in the High Court for 20 years, and yet you find when you're allocating cases, someone should have been a principal High Court judge.
I know what you're saying, but I think there is a little bit of a difference in terms of the judges. By the time you become a judge, you remember magistrate, we are talking about, some of them have come from LDC and straight away become magistrate.
Some of them are members of ALF's Young Lawyers Association.
Yes, which is okay. But you have got a magistrate who has come straight from LDC and become a magistrate, which is not a crime.
Yes.
But you can admit that their appreciation of matters is not
Tempered by experience.
it's not that they don't know the law.
Yes.
But the experience of judging the dealing with the people, the tempers in the court, the managing of your own self as a judicial officer comes with experience. And the more charged the disputes are, the more challenging. And I think you don't want to get a person who is less experienced handling very complex cases. But if you have those ranks, it means that you can, without necessarily going to check on people's CVs, allocate these cases. But also, for career progression, imagine if you were a senior principal magistrate today, as the structure is, and tomorrow they say the law has also removed all those things. You are either chief magistrate or magistrate. So you who has served for 7 years, you are viewed in the same light. You're actually demoted. So I think that it's important to have those ranks, and those ranks help us now to say, let the chief magistrate, I don't know about the earning, but we also touched on it, that as you allocate complex, more work from high court shading work down to the lower bench, you should also talk about increasing their salary and improving their working conditions. But how do the ranks come in? That we are proposing chief magistrate 300, senior principal magistrate 150, principal magistrate 100. Yeah, 100 million in terms of pecuniary jurisdiction. So instead of saying chief magistrate 300,
my friend
and
worship who is one thought you were suggesting a salary.
No. The salary is handled by salary things I learned when I appeared before Parliament, that they are handled by a body called Ujoa. They are the ones which advocate for the working condition. But I also talked about it because for us we think working conditions actually impinge on the capacity of a judicial officer to fairly dispense justice. And I during my campaign I talked to many of these judicial officers, and they told me there are challenges which I think are really need intervention. So if you break them into those ranks, it's also very easy to allocate the pecuniary jurisdiction along those radars.
Thank you for breaking that. Thank you for breaking that down. And now the last question that I'll pose to you before I push it back to Ellison. You have mentioned, it is true, the memorandum describes magistrate courts as the foundation of justice, and then also seeing it's saying that the capping of the value is so low for the of well put and discussed, and they say that as a result the cases that should be handled at the magisterial level end up at the High Court, and this causes a lot of backlog at High Court because this could be handled in the lower courts. So when we talk about this backlog and pressure, would you say that this is a much needed reform, or would you say it is just a crisis that is being managed? Over to you.
It's both. It's a crisis. It's trying to reform, but also trying to manage a crisis. Because if you look at the case backlog records, if you download that case census report, you'll see that we have a problem. It's not humanly possible for the justices of the High Court to dispose of all the cases that they have within a reasonable time. But also, as we reform, we are creating we are managing a crisis in the upper bench, High Court, but by reforming the magistrate court structures and the jurisdiction. But also we don't want to create a crisis in the magistracy. I don't know how many of you were practicing law when we had the land tribunals. Do you remember what happened when all of a sudden they ceased to exist actually? And at first the Chief Justice said those matters should go to the High Court. And then said, transfer. So there was shading of cases from the High Court to the Chief Magistrate's Court. I think about 70% of the land division backlog was shaded down to the Chief Magistrate's Courts without doing anything about increasing on the number of magistrates, improving their working conditions. So I can say we are reforming. It's a problem that requires reform. We are managing a crisis at the upper level, but we should be very careful not to create a crisis in the magistrates' courts. I remember that, and we have made this point before Parliament, and actually we have said that I think we support the idea that the cases should remain, the cases that are already in court should remain where they are. From my experience, a litigant is going to go to Mengo because they have told them your case is no longer at the land division, at the High Court, it's now in Mengo Chief Magistrate's Court. They get there and the file is not there. They get there and the exhibits are lost. They get there, the other side they were using transcriber. These guys are still using pen and paper, and the record is lost. And we will go into that clause 11, which was saying part hard cases can be continued, now almost creating a situation where the magistrate is almost exercising appellate. He never saw someone testifying, doesn't know the impression of this witness, and is now going to make a decision on whether they were telling the truth or not. We all know demeanor issues and how we rely on them to say whether this witness appears truthful or not. So we should be very careful not to create a crisis further down, like it happened in the case where land tribunals were closed and matters were transferred without order. So we are saying no, the cases that are already in the High Court, let the High Court clear its backlog. But new cases can be filed in the Magistrates' Courts. And I think Parliament was convinced by that proposal. But look, the Parliament committee has to make a report, the report has to be debated, and the Parliament has to adopt or reject the recommendations.
And
yes.
I agree with you. I think it doesn't make sense to. I agree with you. I think people who have backlog should carry their load. You know, they shouldn't cast your burdens onto the magistrate. So I think, Joy, I don't know if you still have, or maybe now introduce you to the chief executive or the. But Alfred actually is very well known to Mr. Kusasira, because I remember these spaces were actually started by Mr. Kusasira in the campaigns. He's the one who used to host spaces with Alfred. But that time Alfred, I don't know if he was yet a young lawyer, but now he's a young lawyer, and in fact he has now learned that by the time you started out in the law, he was not yet born. But over to you, Alfred.
Thank you, Mr. Dennis, for joining us tonight. It's always inspiring to listen to you and toast you. When you mentioned that he started the law firm shortly after LDC, when I was like, so you mean even after graduating very soon I can start? Yeah, you come. But we did that at that time. So
Alf, you graduated long ago.
I'm asking on behalf of them. I think the other aspiring bit was that bit of deciding to specialize in mining law at the time when it was not, let me say, training a lot. You saw it's still not training, so you saw the future before you could see it, and that was quite inspiring. And the other thing which he really told me, which I usually remember, is that if you serve the profession, it will pay you. And even as now you're serving the profession, even beyond your normal working hours, and we are glad to have you tonight. So, just when you were discussing the ranks of the magistrates and what they could handle, we ended up even proposing from shifting from 50, not 100, but also to like 300 million. And someone on call was like, maybe in Kampala, the land is that expensive. But if we go for, let me say, Ganga, High Court in Iganga, and if we got that 300 million, Magistrate Court to be able up 300 million, the land there is like quite cheap that you may end up making High Courts in that side redundant, because the land, for you to say that a person is contesting land of 300 million, because you can find an acre at 4 million, 5 million. So if you project it to that extent, you may make High Courts in other regions, let me say Ganga or Namayingo, Bujiri, that side redundant. So seeking your comment on that. And then I recommended the bands of the magistrates, and I know you hinted on it and their practicality, how they will make a difference, having a chief magistrate, senior principal magistrate, magistrate grade 1, and the like. Maybe just to shed also more light on how it will affect justice delivery and not just the profession, the career progression of the magistrates. Thank you.
Okay. Yeah, I think my example of land was just an illustration. I don't want to believe that in Bugiri there are no people trading in large sums of money who have cases that involve money. There's also a very interesting point that was raised by my senior colleague Max Mutavingwa, that now even divorce when people are divorcing, some magistrates decline because the family, the property to be shared is more than the value of chief magistrates.
Yes.
So what is the most modest house in these places? I know that some of them, in my other life I'm a projects lawyer, and I'm always in the field compensating people.
Yes.
And I know that in places like Tororo, just Tororo here, an acre of land in a valley called Sukulu, where there is a phosphate project that I advised on, an acre of land in 2013 was compensated at 39 million, and that is bare land without development. When you add development, I know that some people got 300 million, 500. I know a person who got 8 billion just in one bullet. So I think that there's no harm if the magistrates that side have larger jurisdiction than, because they are growing also. Those areas are also growing. Judges becoming redundant? I don't think so. There are appeals, a lot of appeals in the High Court coming from magistrate courts in criminal matters, a lot of them. And if a judge is redundant, in the constitution also they can shift you around. You can come to Kampala and help us if there's nothing you are doing in Jinja. But I think that it makes sense to expand. So the other question was, you're saying, isn't this a career progression idea? It is career progression. Without career progression also, you will not have people attracted to the judiciary. So you will not have judicial officers in the first place. So career progression is good because it will attract people to the judiciary, and good people. But also, I think people would feel more comfortable to see an experienced judicial officers handling their complex matters. So there is a lot of merit in it. The more experienced the person is, the more you want them to handle your matter. That's my thinking.
Yeah, thank you. Now, we have talked so much of civil cases. I think we should get the criminal side now. Now, looking at the criminal side, one of your boldest proposals is expanding the criminal jurisdiction of magistrates so that they can try very serious offences in it. So first, for a layman on call, what are those serious offences? Maybe we list for them 2 or 3 of them, and then is Uganda ready for that shift to the magistrates handling serious offences? Because I'm now starting to imagine the lawyer's lawyer appearing the Katanga matter, that murder case before magistrate, chief magistrate.
What do the magistrates currently hear? You know, you're saying serious cases. What are they? Are the ones they are hearing? But what cases? Maybe you could also just give us Dennis in your answer, if you could. I think Dennis, in your answer, if in your answer you could just give us also an understanding of what they are currently handling, and then what you're proposing. And just for people who are listening, these are proposals that the Judicial Affairs Committee made to the Parliamentary Committee on Legal Affairs. So we are discussing, my friend, change of law. If you're there sitting down, these matters affect you seriously. So and Dennis was in Parliament taking the members through.
Yeah. Thank you very much. Serious cases and non-serious one. I don't know whether there is a serious case and non-serious. And I want to speak from a criminal law perspective, because if you are in jail, it doesn't even matter whether you are there in a serious case or non-serious.
Whether it's traffic.
Yes, because once your liberty is taken away, it just doesn't matter whether it is taken away as a civil debtor, either it's taken away as a traffic offender, or a person who has committed a misdemeanor. And I am one of those people who don't subscribe to a pejorative tag, looking at magistrate courts with a pejorative connotation.
Well, pejorative is a person, is
kind of looking at
down.
them as, how can I even appear there?
Looking down.
Yeah. I remember in my first my first time to appear before a court. Of course, me, when I finished the Law Development Center, I was not interested in being employed anywhere. I'd been in the law firm. There's no way you're going to convince me to go to a law firm. So I was one of those rebellious lawyers who said, no, I'm going to just go and open my law firm. And somebody can come and tell me what is the law which says I can't. There was this 3-year law. You must practice for 3 years. I looked for it. I didn't see the rule. So
another rebellious young lawyer is going to take over from you.
yeah, so I said no, I will open. Then they gave me a PC of 9 months. Is it what the PC of?
Yes, that first one.
Of Magistrates Court. So when I opened my law firm, the first client I got had an appeal in the Court of Appeal. And I'm not going to chase away a client. So I just got my gown and went to the Court of Appeal. So I even frog jumped the High Court with my PC of
9 months
of Magistrate Court, so called. And I remember State Attorney, it was a criminal matter, an appeal. My client trusts me, doesn't want any other lawyer except me. And the other says, this man just got his PC the other day. He has no audience in this court. So I was able to come out of that and say this one is a colonial rule. I don't know the purpose it serves. I don't know whether there's a difference between people who are seeking justice in magistrate courts and seeking justice in the High Court and seeking justice in the Court of Appeal. Is there a difference in justice? And I said I don't think that rule can stand in the face of constitutional provisions. And I remember Justice Chikonyogo advising the other man to to concentrate on the merits and get on with the appeal, which I won, of course, with my so.
I like, of course.
So the magistrate court, there's nothing wrong appearing there. They dispense justice like any other court. If you can go to the tax appeals tribunal, Edison, don't you go to the tax? If you can go to a tribunal, don't you go there?
Electricity disputes.
The largest case that I've handled in my life started at the tax appeals tribunal, which is probably the largest case in the commercial court of Uganda. It started in the tax appeals tribunal. It's a tribunal, but we appear there. Just because the tribunal can handle cases of large sums of money, they don't have this tag of lower bench, is it what? So we believe also if the magistrate courts are empowered to handle what you have called serious cases, the lawyers won't have a problem appearing there. In any case, if they have the jurisdiction, you must appear there. You must appear there. One other thing you should know is that the more you start at the lowest level of the judicial dispensation, the more justice you're likely to get, because the appellate layers are more. So I see a lot of merit in starting at the lowest, and I end up in the Supreme Court on a third appeal on a question
Of law.
of great public importance. So what are the magistrates courts handling as of today in terms of criminal jurisdiction? I think section 161 of the Magistrates Courts Act provides for the criminal jurisdiction of magistrates court, and I think chief magistrates currently can hear cases where the maximum penalty is life imprisonment, other than death.
Yes.
And the other ones can handle any other offenses except life imprisonment and death. But there are so many offenses that have got death as a penalty. Of course, we always think about murder only, which I also don't see anything very special. Murder. We all study criminal law. What are the number of years a lawyer should have practiced to become a judge of the High Court? 10. Don't we have magistrates who have served for 10 years?
A large number.
A large number of them. And unlike you, a lawyer who has been busy in your land matters only, or adoption only, this person has been dispensing justice for 10 years. If you a lawyer, you can go and become a judge and try murder. What makes you believe that a chief magistrate who has actually served for 10 years in the judiciary cannot deal with a murder case? They can deal with murder case. But there are others like aggravated robbery, I think kidnap with intent. There are so many. I'm not a very big criminal law practitioner. I think in my life I've handled only three criminal matters. One was for my uncle and two only for the clients. So I cannot name off the cuff which are those cases, but we are saying that the chief magistrate should be, the jurisdiction of a chief magistrate should be enhanced to allow them to try offenses in respect of which the maximum penalty is death, except treason and terrorism, because we believe those cases have a certain rigor around them. They're a bit, if I may borrow your word, serious cases, and they have a lot of complexities around them that we think they should remain in the High Court, and the High Court should be left alone to deal with very, very serious business and appeals. We don't think that that would be a very bad proposal. And then the senior principal magistrate and principal magistrate should be able to hear cases in respect of which the maximum penalty is life imprisonment. And there are so many of those. What will that do? Right now, the High Court has to wait for sessions. Because how many judges of the High Court do we have now? About 65 by head count? 65. How many High Court circuits do we have? Very few compared to magistrates' courts.
Yes.
But these judges have to wait for sessions. And if you go to the prisons and see how many people are languishing in jail, waiting
for the next available session.
It's saddening. We think that magistrate courts are hearing cases on a day-to-day basis. Day-to-day basis. Those are the courts that should be able to solve the problem of congestion in prisons and even backlog. They're hearing cases on a daily basis. But that means you have to look at how they are recruited. I think only the magistrates, in the judicial officers, I don't know what the framers of the constitutions were thinking. They prescribed qualifications of a judge, justice of the Supreme Court, High Court judge, Court of Appeal, but said totally nothing
about the
qualification of a magistrate. And the Judicial Service Commission Act, which is quite a disappointing piece of legislation, did nothing to help out. And we have a serious problem as the Judicial Affairs Committee with that law, by the way. We filed a constitutional petition to challenge it, the constitutionality of that minimalist legislation.
It was written with the 1967 Constitution in mind.
It was actually written in 1997, but after the Constitution says Parliament shall enact legislation, shall make laws actually, to prescribe, Parliament shall make law to facilitate and regulate, the functions, the Judicial Service Commission and the President in the discharge of their functions under Chapter 8. When you go back home, go and look at that law and show me whether that law facilitates and regulates. The starting point is that it failed to prescribe the qualifications of a magistrate. So what do you have now? And I have no problem with young lawyers becoming judicial officers, but also the judiciary cannot be a repository of people who are only looking for jobs. In Kenya, the law prescribes a qualification, experience of at least 3 years.
Post-qualification.
Post-enrollment. Post-enrollment. Now we don't have. So you have a lot of people going in without knowing whether these people actually understand. Yeah? You know, all of us have been young lawyers before. I told you I went to the court with my PC and I won the case. Good. But I don't think I could be a judicial officer. That law did not do anything for us. It has not regulated the Judicial Service Commission in the way discharges these functions. It has given them power to become complainant, prosecutors, judge their own cases. They have no timelines for disposing cases. You have judicial officers with charges hovering all over their head for years and years and years. The most ironic case that I read, which I was going to summarize before I dropped out of the race, was of a judicial officer who was recommended for dismissal for failing to dispose of a case in 60 days in a magistrate's court. But that case of his took 5 years for the Judicial Service Commission to dispose. So we have a problem with that law. So what am I saying? That as we advocate for enhancement of criminal jurisdiction, we also need better sieving of who becomes a magistrate. What is the criteria for becoming a chief magistrate? You must have served for how long? What is the performance parameter? What are your KPIs for you to become? They are not known, and these are very serious things, because the more opaque these parameters are, promotion, appointment, only known to the members who are sitting on the Judicial Service Commission, the more less confident we are in the propriety of the appointments. And we see somebody is a chief magistrate, but the person who entered the judiciary before them is still grade 1. And the other person is a chief magistrate, and which could be a reward of hard work, but we don't know. So that's just the debate can go on and on. I don't want to turn this into, I know this is a Judicial Service Commission conversation, but let's not dominate it with JC.
This one we decided outside out at the service conversation, but it has now the parliament of the, actually it's now the lawyers' parliament, so it is beyond that. So you can always discuss man that. Maybe just one question from me. The final one is, you also proposed the abolishing committal proceedings. So for the laymen on call, or even for the lawyers who may not understand, what are committal proceedings, just in layman's language, and then why do you believe that they no longer serve any useful purpose in the magistrate courts? Thank you.
Where is my? Thank you very much. I'm just diving for a gem of a paper written by my Lord Chief Justice Emeritus Benjamin Odoki, which I encourage everybody to read. Maybe I'll share it. This paper was written in 1994, again before you were born, Alfred. It's called Reducing Delay in the Administration of Justice in Uganda. Reducing delay in the administration of justice. The case of Uganda. And he makes a very nice line that rings in my head all the time. He says, justice is sweetest when it is fastest, and becomes sour when it is delayed. That very important line, coupled with our own constitution that I anchored my submission. My submissions to our submissions to Parliament, they're not mine, they're for the bar. To Parliament were anchored on 2 provisions of the Constitution, and that's where I base my case to say abolish committal proceedings.
But this is the challenge. This is where the challenge was, where they are saying that that it's not.
We will get there.
Okay.
Article 126 of the Constitution is the bedrock of
Judicial power.
Judicial power. The Constitution requires judicial power to be exercised in conformity with the law and with the values, norms and aspirations of the people. It further requires, among other things, that justice shall not be done to all irrespective of status. Justice shall not be delayed. That is quite important in the context of the push for abolition of committal proceedings. And that substantive justice shall be done without, shall be administered without undue regard for technicalities. And I think for me, the committal proceedings is one of the technicalities. And I'm here to be convinced the value this procedural step brings to the judicial dispensation. And I will take you to Justice Odoki's paper. Very interesting because it describes the evolution of committal proceedings, how they started, what was the purpose, how were they amended, why are we where we are, do they serve any purpose? And it seems to suggest that previously, under the criminal procedure code, committal proceedings were meant to act as a sieve. In fact, the no case to answer was dealt with during those proceedings. Is there evidence enough to warrant? And they used to happen in the High Court. They were actually called preliminary hearing. They were not committal.
It's like the American grand jury.
Yes, there were preliminary hearings before the High Court. And it happened so that the High Court was spending a lot of time on preliminary hearings. Okay? And they said no. They should go to
The
Magistrates Court. And by then, the witnesses could come and testify, and so they went to Magistrate Courts, and the purpose was be informed of the charge, be told the summary of evidence and what have you. Now they lost that value of sieving. The value of sieving was lost, but they retained some little value of disclosure, the particulars, face, when it was Edison, you were a renowned you know very well what a summary of the case is. So as we stand now, we are serving two purposes: inform the man of the charge,
yes,
which of course he was informed
at the
when
police
he was
station.
At the polling station. Now, this time also disclose to him the case.
The summary.
Summary.
Yeah, not the case, the summary.
Summary. Somewhere we had this case of Soon, where the Constitutional Court said, actually the prosecution is under duty to disclose all, including statements of witnesses, exhibits to be relied upon, everything. So that dealt a blow to the small value committal proceedings we are bringing to the judicial system. Now,
because you can get better disclosure
there
at trial.
At trial, even before, by the way,
Before trial.
Judges who have made it a habit to say it is too early.
But before plea taking.
But you can get them before plea taking. In fact, you are entitled, because I have done it. I have done it in a murder case that I got the DPP to share everything before committal. Before committal, and I said I want. So they gave me, and I was able to convince the DPP that actually my client had no case, and the knowledge was granted. I didn't need to wait for committal proceedings. So, but now look, when you count the number of people waiting to be committed, they can't be tried because they haven't been committed, so they can't get on a session.
Yes.
And when they come to be committed, what value? So I know of a case by Justice Uganda. Man was not committed for 4 years.
This is the one in Masaka.
Yes, 4 years. He's waiting to be committed. So the judge just struck out. Just said stay the what? the proceedings. So no justice for him because we don't know whether he was innocent or guilty. No justice for the victim. Why? We were waiting for committal proceedings. So I've not seen any value, and if you want to know very well the history, the evolution of these proceedings, I will share this one with you, the paper by my Lord Chief Justice Emeritus Benjamin Odoki, a beautiful paper that shows how they used to be and why they were valuable then and why they are not. But also we have done a comparative study as the Judicial Affairs Committee and established that in Kenya they were removed, they were repealed, they are no longer part of the process. In UK they were removed, they were abolished, and I remember reading the report of the Minister of Justice in the UK saying that the abolition of those committal proceedings was going to save 60,000 hearings of those kind of things. I think Republic of Ireland and other countries, they have others don't even have them. So when I was doing my research and asked colleagues in Kenya committal proceedings, some of them says, what are those? They don't know. And I believe that the judiciary also doesn't think they bring any value, because when I was in Parliament, also my Lord Justice Kazare echoed the same point, that the UJOA do not think that committal proceedings serve any purpose today. And also, by the way, UJOA was also advocating for increment of the criminal jurisdiction, enhancement of criminal jurisdiction of magistrates, meaning they are actually ready to deal with these cases.
Okay. If you're just joining us, welcome to the Judicial Service Conversations. We are having a conversation with Mr. Dennis Kusasira. Dennis, maybe just before I go to my other colleague, we've gotten a number of questions from the public. Mr. Derek Kakoza is asking, why do citizens lose faith in the justice system, and how central magistrates courts in rebuilding that trust? And a lot of people are worried that if you increase the criminal and pecuniary jurisdiction at the lower bench, will it enhance trust, or will it erode the trust? There's a question from Ambrose Emron who says, are there implications in increasing community-based sentencing and restorative justice? There's talking about devolution to judges. But I think if we first look at Derek's question, which I think is a pushback on your argument, because he's saying, will this erode public trust? Because at the moment, I think if you did I don't think it's controversial to say that if you did a study right now, I'm told the studies show increased trust in the judiciary, but I think when you hear from at least practitioners, there's a serious concern. You talked about the pejorative nature on which lawyers look at magistrates. I was once, actually, a colleague of mine was once appearing with a senior colleague before a relatively senior high court judge, but the lawyer was extremely senior. And when the very senior lawyer left with the junior colleague, he informed the colleague that I'm going to stop appearing. The senior colleague and the judge had exchanged in a back and forth about a point of law. But to this senior, it was a very simple point of law that the judge really should have known. And I think the judge understood it after he explained it a bit. But as he was leaving, he was a very elderly man, and he told a younger man that, I'm going to stop appearing before magistrates. And they told him, no. Counsel, that's the High Court. People have this view that that especially because of the maybe the junior recruitment nature of the magistrates, that in some magistrates courts there's a process of trial and error. So the question is, will enhancement improve the trust that the public has in the courts? And also, can you comment on the question of whether the trust in courts today is really at an all-time low, and is it on account of the fact that many judicial officers, even at the higher bench, don't seem to have a lot of experience with dispute resolution?
Yeah, you remember when I was starting, I said that the quality of justice, experience has taught me that the quality of justice heavily depends on how the judiciary is built, not how it decides cases. So the starting point is how are judges appointed. How are judges appointed? If the appointment process is opaque as it is today, if it is exclusionary as it is today, and why am I saying exclusionary? I remember seeing an advert where they said for the position of registrar, chief magistrate, and something like that, attach 4 judgments that you have written. And lawyers were asking, so where do I? And one lawyer told me, but I know lawyers who write judgments.
Some of them are being attached by
somebody. I have not written a judgment. I want to join the judiciary, but I have not written a judgment, actually. So once you don't have a clear, transparent judicial appointment process, that is where the whole problem starts from. You may say, why does he say we're not transparent when we advertise? Yes, you advertise. But nobody knows how you arrive at your decisions to appoint person A and not give person B. So the people begin to think that those who are being appointed are not being appointed on merit. So that's where the problem starts from. And of course, because you lack a structured way, you're likely to let in a little bit of chaff. And they churn out very dubious decisions that even a lay person can say, "Yee, uyo mulamuzi ki nange atali mulamuzi nkiraba." In the historic days, we used to have ebitawuluzi. I don't know whether, Alfred, you've ever heard of ekitawuluzi. Okutawulula. And those members could churn out better decisions than some of the judicial officers that we have. So I think that confidence in the judicial system is not very high, and it can be illustrated by the number of people who take cases to RDCs. But you can't blame all that on the judiciary, though. Because you have a problem at the start when you are appointing, you have a problem in the middle during the hearing where cases delay too much, and sometimes also if finance lawyers are responsible. Somebody says so and so is indisposed, I am holding his brief and I'm not ready to proceed, so the case won't be heard, they push it to another. Then you have a problem.
Indisposed means he's not well.
He's not well.
I know someone who said he's going to be indisposed.
He's going to fall sick. He may fall sick.
And he's here, I can see him, but
he may fall sick. So you have a problem when you're appointing a judicial officer. You have a problem when the judicial officer is dealing with the case. You have a problem when the judicial officer has delivered a decision, you cannot enforce it, because also there's a lot of encroachment on judicial power. So that causes all those a combination of all those factors causes people to not trust that you will get anything from the court, and that is very bad, because once people lose trust in court, they resort to mob justice. I know in the mining sector, the people who are trading gold, they have a term they use, that they will send you some nice fellows. They mean they're going to kill you. They'll send you nice fellows if you don't pay our money back. You told us this, and now you send you nice fellows. So people will resort to those kind of rudimentary ways of dealing with their problems. Not ADR.
No, that seems to be an alternative dispute
for them.
Yes.
And obviously, someone asks that they believe that increasing jurisdiction of magistrates court may make people lose confidence. The confidence is low.
Yeah, will it enhance confidence?
Will it enhance? I believe
or erode?
We are not only dealing with one problem, confidence, lack of confidence. We are also dealing with case backlog, delayed justice. You go and ask people in Ruzira today that are you more comfortable to wait to be tried by a judge, or you think if we took you to a magistrate and they try you, you'd be better off? Probably 100% of them would say, let me go and be tried by whoever. So I believe that confidence is not much about, because people also don't have confidence in the High Court. And also they have no confidence, some of them, in the Court of Appeal. And I remember there was a election petition where people had no confidence. They said they withdrew their case and they took it to people's what? People's court. So some of these look like drama things, but they send a very strong message on what people think about these courts. So the confidence building is got nothing to do with the pecuniary jurisdiction of a magistrate. The lived experience of people who are in jail will tell you that they prefer that jurisdiction to be enhanced.
Okay. If you're just joining us, we are soon winding down the conversation on the Judicial Service Conversations. We had said we'd finish by was it 8:30 or we're 30 minutes in, but we just have a few more questions. Just a few from Mercy Makabai Chemutai, the indefatigable Mercy. Her questions are usually merciless.
Thank you, Ellison, and thank you to everyone who is joining us today. It's indeed an honor to sit opposite you and ask you a couple of questions. On this issue, when you look at the memorandum in the bill, I think item number 2 on the defects in the existing law, it highlights, one of the paragraphs highlights the issue of case backlog and how there are matters that are before the High Court that really should be before the Magistrates Court. I was attending a court session recently, and the judge, I think the matter, when they filed it was 70 million, and now the matter had reduced to about 55 million, and the judge was really wondering why he was handling a matter of such a value at the High Court, yet he has cases worth crazy billions, and he was insisting that the parties should actually consent, and he doesn't think this is something that should waste court's time. And I think that, in my opinion, is the understanding behind why the value, the issue of inflation, and why the value for the magistrates' courts needs to increase. Looking at it from that angle, do you think, and what do you think that increasing the pecuniary jurisdiction of magistrates court will lead to increased access to effective and timely justice? Like, what do you think the value is actually going to be, and what mitigations? Because how can we ensure that this proposed change improves access to justice and delivery of timely, effective justice through courts from a case backlog perspective? And what do you think as well discussing this particular bill?
As I said when we were starting, is that magistrate courts are more in numbers than High Court. Magistrate courts are closer to the people. Magistrate court is actually the first level where people experience justice. If the High Court is dealing with most of the cases, because I've told you that 50 million is not a very little money, because I don't have it now on me, but people have it, and they donate it and whatever. So cases that are beyond 50 million are just too many. That if you want only the High Court to deal with them, or even cases of 100 million, if you want the High Court only to deal with those cases, the High Court is too far from the people. So people trek miles to come to the High Court to bring witnesses. It's painful for them. If the jurisdiction is increased, then the justice is brought closer to the people. But also, justice will be faster, because magistrates' court are more, they have more judicial officers than the High Court, and they are more energetic because they are still young people. Most of the judges, you can look at them and you really also sympathize with them. Some are too old, some are sickly, understandably so, because they sit a lot. So I believe that there is value in increasing, because of bring justice closer to the people and speeding up justice.
Thank you very much. I want to take you to Clause 11 of the bill. Clause 11 proposes that the Chief Magistrate, either through the parties or on their own motion, can decide to have a matter transferred to the High Court or transferred from a magistrate to themselves to handle, whether it's already been heard or it's still in the hearing process. You imply that this particular clause could interfere with judicial independence. Why and how would that actually, how would this particular clause interfere with judicial independence?
I think it's only fair to put it in perspective, and let me read that clause. Because it's very difficult to illustrate. Yes, hold on. Yeah, you can actually read it for us. Start with the proposed 217A, subsection 1A.
Okay. 1A says a Chief Magistrate's Court may transfer any suit, appeal, or other proceeding pending before it or trial or disposal to the High Court. A Chief Magistrate's Court may transfer any suit, appeal, or other proceeding pending before it for trial or disposal to the High Court. And then B says a Chief Magistrate's Court may withdraw any suit, appeal, or other proceeding pending before a magistrate and 1. Try or dispose of it, 2. Transfer it to the High Court for trial or disposal, or 3. Transfer it to another magistrate for trial, or return it to the magistrate from whom it was withdrawn for disposal.
Have you seen the chaos?
Yes, there's a lot of chaos.
Have you seen the chaos with that section?
I think there is even more chaos in 2. And where it says that where any suit or proceeding has been transferred or withdrawn under this section, the court to which it is transferred may, subject to any special directions in the order of transfer, either retry it or proceed from the point at which it was transferred or withdrawn.
So you can imagine, A, Chief Magistrate Court transferring a case to the High Court, a case which was pending before it for trial. Because what is the spirit of this clause? You can get the spirit of this clause from reading the memorandum to the bill. And the spirit is good, but the person who drafted did not achieve what the memorandum is saying wanted to achieve. Right now, if you file in a wrong magistrate court, the result is that your matter will be dismissed, because a magistrate court cannot proceed any further with your matter because it lacks jurisdiction, pecuniary or territorial or otherwise. And that is injustice to the parties, because they don't choose where their lawyer files the case, but they have paid fees. Then you dismiss the matter. So the idea, if I read the memorandum, was that if you file in a wrong court, say a magistrate court, and say right now the magistrate court has a pecuniary jurisdiction of 50 million, and you file a matter of 70, today the magistrate court must dismiss. It has no power to transfer. The bill is proposing, instead of dismissing the case, you transfer it to the High Court where it ought to have been filed. But where I have a problem with it says pending for trial. The case which was filed in the wrong court, which has no jurisdiction, cannot be pending there for trial. So that's the starting point. When you say pending for trial, you mean that even a magistrate can just decide a matter where he has jurisdiction, and the matter is pending before him for trial, or another magistrate for trial. He removes the matter from that magistrate and sends it to the High Court. I think it should be explicit, and we've proposed that where a matter is filed in a court which lacks jurisdiction, the Chief Magistrate's Court where that matter has been filed may transfer it to the appropriate court. So if it is the problem is with territorial, you file in Mengo instead of Nakawa,
Send it to Nakawa.
let them send it to Nakawa instead of dismissing it. If it is you file in the Mengo instead of High Court, let them send it to High Court, just like the High Court does
For the divisions.
for the divisions, even for I've seen
For
Justice Nyanzi one time asking, I was with my land friend Ellison, and the Justice Nyanzi said, what is so Kampala about this
matter.
Sukulu
Can we go
hills
to
in Tororo?
Mbali?
And they wanted to send us to Mbali, but we said, but you know, all of us are here, the clients are here. He said, okay. But now, the second part, B, has real problems. And I told you, for us, our memorandum was premised on two principles in the Constitution. The second one is Article 128, judicial independence. I can't imagine a magistrate finding one says the matter and says, give me that file. And I give it to another magistrate. Or give me that file and I handle it myself. Or I took this file from you, I've returned it, now you can handle it. Because it's talk about remove from the magistrate, take it to another, hear it, return it. What is this? So if you've read the decision of Imainda Goha versus I think URA,
yes,
Justice Mubiru talks about administrative interference in live adjudication. And I think the drafter wanted to recast section 215 of the MCA, which gives the High Court those powers. But you know, the High Court is the High Court. It's not the same court on the same level trying to intermeddle with live adjudication cases. And I think Parliament saw the point. I believe also the drafter will see that that's not a very good proposition. That's not a good proposal. The one of hearing cases that were part-heard is also a bit problematic, because you've had the Supreme Court pronouncing that the judge who didn't hear fully the case cannot sign a judgment of the Court of Appeal or the Supreme Court. I believe there is value in the judicial officer seeing the witnesses testifying and handing over a matter to a judicial officer who did not see the witnesses testify is not very good. I know that we have had cases when judges are promoted and we start from where we stopped, but still, I believe if you ask most lawyers also that occasions a little bit of injustice because sometimes the other judge, the way they were, writing the notes, it's not very easy to follow. Now we are on transcriber. Some of us, our accents are not so good. In fact, when you go and request for the record of proceedings,
you find you
say, am I the one who said these things?
You find you are speaking Japanese.
You are speaking things that the computer cannot even think about, including your names are misspelled. So, but if the judge was listening, even if there are errors in the transcription, they kind of recall what actually was being talked about. That is our take on that provision.
Thank you very much. My last two questions are really from the perspective of an ordinary person who is listening in today. Number one, if I've already filed my case at the High Court and its value is maybe 150 or 70 million, and then this bill is passed into law, what happens to my case? I think speaking into the transition clause in the bill. And number two, if your recommendations in the report that the ULS has provided are adopted, what changes should an ordinary person using the Magistrates Court expect? And okay, if the changes that are recommended in the ULS report that was provided to the Parliament are adopted, how will those changes impact an ordinary person who is using our magistrate courts today, in summary? So those two questions.
Yeah, the first one, we are proposing that the cases should remain where they are. The files should not be transferred because we have the experience of the land tribunals. Files getting lost, cases taking 10 years because some exhibits are lost. Some people have handed to court land titles as exhibits. So in the transmission process, the files get lost. Exhibits get lost. So we think that the transfer of live cases that are ongoing will negatively impact on the people, and we think the cases should remain where they are. But again, I don't want to over-repeat myself that they will bring justice closer to the people. That is my view.
Okay, if you're just joining us, welcome to the Judicial Service Conversations. We are soon winding down our conversation, and I'm seeing a lot of interest and very many questions. But we also have with us here Mr. Kato Mpanga. For those who do not know Mr. Mpanga, he's how can I describe you, sir? He's a mzungu. He's a very, very serious mzungu. He works in the UK as a solicitor, and he's been a strong supporter of the Ugandan bar. I think you have an agreement with the Law Society, and he has come in. Dennis, he's here seeing you making all these wonderful proposals. And so maybe just before we wind up, I must say that of course he's very well educated. I know some people may not like it when I say this, but it's not his fault. He's a Budonian. so he's an Obi of Reina. But he's also a solicitor in England and Wales, and he has represented a number of people in the courts in the UK. I'll leave his full profile. We shall host him one of these days. But Mr. Mpanga, I don't know if you've been following the issues of our magistrates' courts, I know you've been following issues about magistrates courts, but now as a summer, as a guy who appears before, because you see in the UK you have a very interesting court system. You have recorders, people they call recorders. You have people they call deputy judges. You have a very, very complicated court system. Admiralty for the soldiers, of course. You have very specialized courts. You have high-tech hearings. You know, we're talking about committal proceedings, and I actually forgot to say, and maybe we'll come back to Dennis on this later. You know, committal is a trick. You know what it used to be was preliminary hearing. What was always in the mind of the framers of the Constitution, for example, was that after committal you have a trial immediately. So they gave time limits for how long you can be committed. They say you can't be committed. If you're in committal for more than this number of days, you have an automatic right to bail. This is in our Constitution. So what guys do is they, on the day you are supposed to qualify, they commit you, and then you wait for 10 years. If it became a trick. So I don't know. The question may be long winding, but just give us a feel of the UK system, the Uganda system, and of course I know there's something we have in Uganda that you absolutely do not have in the United Kingdom, and that is the judicial service conversations. But over to you.
Thank you very much, Mr. Karumaga. I'll start by giving that sort of comparison, and then that candidate requested by Mr. Mujes to make a few comments and also ask a question. So I'll be able to do that. 2 minutes. Okay, I'll try to make that one. I mean, certainly very, very inspiring what Dennis has kindly elucidated. And of course, I must say I'm a young lawyer who is not as qualified as you are, but I specialize in education law, and particularly special education needs. And that what means is that we appear before the tribunal of special education needs and disabilities. Now, in terms of comparison, and now this is a civil sort of, matters, precisely the government of the United Kingdom allocates about £6,000 for each child in mainstream schools who has special education needs, for example, autism, ADHD, and so forth. Now, the parents of these children find out that these children have needs which exceed what the budget can accommodate. So what they do is that they write to the government and tell them that, look, we need more funding. It could be a one-to-one and so forth. And then, of course, government, through particularly a local authority, is likely to say no because they don't have the funding. But then they advise them of their right to appeal. Now, when they appeal, that's when they go to the first-year tribunal for special education needs and disabilities. And then the cases are picked up from there. Now, in terms of comparing that particular system, which I believe I very well understand, to say, the magistrates reforms that, for example, being proposed. I do not know, I might be wrong, but I do not know if a possibility of specialist tribunals would be relevant. For example, I specialize in special education needs most of the time. I could argue I know 90% of it. I'll probably read where the judge is going and where the matter is likely to go as well. And that then could help. So, for example, say a couple of cases that we have, we've managed to get consent orders, and then that increases, the faster access to justice. I realize I have a minute. So, I think, and I'm more than happy to be guided, because I appreciate my experience is not vast as all my seniors here do have, but I think increasing those special judges and the practitioners understand what they're up to, and perhaps there could be a faster dispensation of justice. Now, that is to answer that, and then I'll try and rush through this really quick, because I wanted to just extend a few thanks as an outline, introduce some of the young lawyers that I came along with, conclude, then ask questions. I'll try and make it really quick. So I'm so grateful to Mr. Edison Karuhanga and his team. It's very, very much appreciated, the invitation through Mr. Alfred Muyaka and certainly Reina for giving me the opportunity to say a few things. Mother Teresa once said that I alone cannot change the world, but I can cast a stone across the waters to create many ripples. What is being done here, the resources that are being invested in this conversation, the efforts, the tireless consistency, I think is testimony to that, casting that stone, and hopefully there will be a ripple of transformation in that regard. So I'm so grateful, Mr. Allison, for this opportunity. I'm humbled. Who am I? And I usually follow up this podcast, of course, online, and I've had also the opportunity to participate online. So that is very, very much appreciated. Mr. Kosasira, you identified a very, very wonderful quote, and I really appreciate the research, the experience, the depth and vastness of your, and the reason why I like to listen to this podcast is because of the quality of the people that it hosts. And you said that justice, of course, you quoted my Lord Chief Justice Emeritus Benjamin Odoki. Justice is sweetest when it is fastest and becomes sour when it is delayed. I think that is something really, really important to note, and it's certainly absolutely very inspirational. Now, as I almost come towards the end, now I come to the introductions bit. Perhaps when I introduce you, my fellow young lawyers, you could stand up. So I came along with Mr. Isaac Henry to Musime, who's a junior associate at KTA Advocates. Thank you very much. I also came along with Miss Deborah Kisache, who's a young lawyer on track to enroll as an advocate. I also came around with Mr. George Kalule, who's an old Budonian and a third-year law student at UCU. How I wish we all could ensure that we get these very important people's contacts and we network with them before we leave. So, finally, I'll paraphrase Nelson Mandela in his book, Conversations with Myself. Our fondest hopes and fervent dreams may not be achieved during our lifetime, but the value that during our time we did our part, the value that during our time we did our best, the value that during our time we played our role is in itself a true reward. Once again, Mr. Ellison Karuhanga and your team, I'd like to thank you very, very much for the efforts that you're putting, the resources, the efforts that you're putting. And I know that in one way or another, it will contribute to the wider transformation of building of the judiciary in this country. And now, finally, as I ask a question, I picked a key lesson from Mr. Kusasira's presentation, and I ideally think would be the quote of the week on this podcast, if there is anything like that. The quality of justice is built on how the judiciary is built, not how cases are decided. And certainly that's that by Mr. Kusasira. And the question that I have in that regard, sir, is in view of the magistrates, courts, and the future of justice, what are the three key things which are, in your view, need to be focused on in order to improve the quality of justice in Uganda? Thank you very much.
First of all, welcome, young lawyers. I really admire you. You have a blank page on which you are going to write your story. And it's up to you what story you want to write on it. I only encourage you to not be fixated on using the conventional path, and try to be adventurous and look at other ways of shooting to the top by getting into practice areas that others are not in. The way Mr. Katompanga has done it is what I did when I was setting out. I wasn't going to compete with anyone in banking. I wasn't going to compete with Mr. Nangwala in land transactions and litigation, Mr. Masembe in banking, and I just went to oil and gas and mining, and somehow I managed to catch up. And now when I look at the ranks by chambers, I see that somehow we are punching above our weight because of specialization. It's very important. The other thing that Edison maybe needs to host someone from law council to tell us the value of, when you talk about the value of committal proceedings, we also one time should talk about the value of certificate of eligibility of a young lawyer. You've gone through it. Every time and again I pull up that file and I want to see the value of this process. They just wanted to know whether I know how to write my name, where I was born, where I studied. That's all. But young lawyers are waiting for 3 years, 4 years, just to go through that needless step. Why not leave the Law Development Center, go to Uganda Law Society, become a member? Uganda Law Society writes to the Chief Registrar, forwarding all your qualifications and requesting them to put you on the roll. Even this function has lost also. It's also one of those outlived. When back in the day, enrollment, they used to be enrolling the 10 advocates, and yes, I remember I enrolled with not that we are at the same level. Justice Monica Mjenyi had served in the Ministry of Justice and also had served in privatization unit. So the state attorneys normally don't enroll, they just, and then she came to enroll with us, and for her, of course, she related back to when she ought to have enrolled. But they used to talk about you. This Mr. Ellison is a whatever, man of what, and then the chief just. But now I see the young people are shoved into a room, they sit there, but they have to wait until they are 60 or 70, something like that. And I have them in my law firm who have been waiting for enrollment for 3 years, 4 years. This is bad. You should host the Secretary of Law Council to tell us what is the value of this process called certificate of eligibility and gazetting. Because you can attach your certificate of good conduct, your qualification from LDC, from the university, to recommenders. Go and be registered, entered in the roll. Don't surround young people. But that's for another day. So, you talked about specialized tribunals. We are in the reverse gear for that. Because we are in the reverse gear for that, because in the Mining Act, there had been sections to establish the mining tribunal. Because mining companies don't like court. Their licenses are time bound and they are very short. And the business is so cyclical. There are times for exploration, there are times for mining, there are times for doing everything. So by the time you come out of court, you are in a downswing of things. So, but the parliament scrapped it because of RAPEX. Edison knows more what that thing means, RAPEX. So land tribunals, of course, we tried them. You saw what they brought for us. But the constitution envisaged that kind of thing you are talking about. But I think either we are not prepared for them or there is no emphasis on them. But the Tax Appeals Tribunal is doing a wonderful job. I don't know whether we have any other tribunal. Electricity dispute, I don't know how many people go there. I have heard of Leadership Tribunal. I don't know what those guys are doing.
Umeme used to go there a lot. But
ever since Umeme left, and now the government, parastatal is the one now suing the government, being paid is a problem. People don't go there. Umeme was a bit shy. If you sue them, they could even settle.
No, they
I don't know
used
that.
to take the
And also used to take there. The leadership code, I don't know what those guys are doing, to be honest.
There's insurance.
Insurance Tribunal is doing a good job. So maybe what you're saying is right, and I think somebody talked about it. There was even, I think I heard of the tribunal's bill or something like that. But I don't know what happened. Maybe you'll one time host the Honorable Attorney General and he will tell us. Could have Kada, you know. What are the three things? Back in the day, I tried to be a trader.
Successfully.
I failed, obviously. But they were telling me there's a gentleman called Kiyimba Freeman. He told me, young man, the thing that you must get right, there are three. Location, the second one, location, and the third one, location. Then one time, my Lord Justice Uganda Ntende came to speak to us in Law Society and said, what makes a good lawyer? There are three things. Consult, second one, consult, and the third one, consult. So my mantra now also, as I said, and I'll repeat it, that the quality of justice depends heavily on how the judiciary is built, not how it decides cases. So my mantra now also is appointment procedure, appointment procedure, appointment procedure. And I'll leave it at that. Those are the three things. Once you fix those, I think everything else will fall in place.
Okay. Mr. Mpanga, you wanted to give us one sentence.
Yes, I was just quickly adding in terms of the enrollment process. For example, in my own case, when I did, the law degree, LDC, master's not compulsory, got the training contract, did that. The moment did an extra exam, the moment that was done, paid the necessary fees, and the enrollment is automated. So that is how quick it could be, and that that perhaps is something they would probably advise, perhaps benchmark with the Solicitors Regulation Authority or the UK Law Society and see how to align things and make things easier. Thank you very much.
When we have it here on the Judicial Service Conversations, that it is possible for...
We're going to look at it because there is also a relationship between client-lawyer ratio. If you have fewer lawyers, also you have backlog. Because I have a lawyer friend who every time when I appear with him and I say, okay, the judge is asking us when we are free, and he flips the diary and you can clearly see that the man is busy. I'm not around. So it's just one lawyer serving too many clients. So the more you delay the lawyers in the pipeline, also the more you compromise the quality of justice people get, because they can't get access to lawyers. So it's somehow linked.
Okay, if you have just joined us, we are coming to the end of the conversation, and we have learnt a lot. We have listened. We have kept Dennis here much longer than I promised him. I told him 8:30, but I meant 9:30. But now, final parting question. Traditionally, on these conversations, we end with a song. The song used to be Molimu Jawa. These guys here seem to have gotten fed up with my song. I'm not sure. But anyhow, what would be your parting shots to someone who's listening to us? And after you tell us your parting shots, we want your parting shots, that is your overall, just with the final things you want to say. Anything, as we say, anything you want to add, kindly add it. Then we want to take two things from you. A number of people who are listening, lawyers, non-lawyers, some people are even requesting to speak. They'll forgive me, we have run out of time and we're being run out of the room. But I think parting shots, and then many people want to know what books you're reading. If you could tell us a few books, you could tell us, I'm reading this. I have the fortune of never having to answer that question because I may be exposed. But also what books you're reading, and then the song, the Dennis song, that song that is really going to my favorite song, actually, I must confess. I'll not say, but I think there was something proposed here by Jude Biamukama, which but anyhow, you never know. You may top the song, of course. Yeah, over to you.
First you say you can't say anything. Nothing will be used against me.
And also be a podcast.
I'll start with a book. Books. I read many books, but the one that I recommend everyone could read will amaze you. It's not a very big book. It may not be a very catchy novel. It's a little book by a man called William Strunk Jr. called Elements of Style. Classic edition of 2008, includes a study guide, but okay, Elements of Style is simply a book that talks about English. Writing, knowing I am sure that if you ask very many people the 9 parts of this of speech, they will fail. Noun, article, adjective, pronoun, verb, adverb, proposition, conjunction, interjection. 9. And the three essentials of effective writing. So I like this book very much because it has made me a lot of money. Because all statutory interpretation is about language. And I think one of the biggest cases I've handled, I won one of the grounds of appeal on this book, because it just tells me where to place the comma, where to place the semicolon, colon, and I find those a lot in the statutes, and I'm able to know how you interpret a disjunctive and conjunctive provision. That is that's why when you ask me, I even pulled it out of my bag. This one, even when I'm going to board a plane, I walk with it. I go with it. The other book that I like very much, that I read and repeat all the time, is a book by Robert Greene called Mastery. And it's a very interesting book. It just tells you about how to shine your master. Not master, your mentor. You the mentee. And I like the quote that he has from a German, I think it's a German guy called Johann Wolfgang von Goethe, and says everyone holds his fortune in his own hands. Like a sculptor, the raw material he will fashion into a figure. But it's the same with that type of artist's activity as with all others. We are merely born with capabilities to do it. The skill to mold the material into what we want must be learned and attentively cultivated. He's trying to say that we are all born with equal chances, and everyone is holding their fortune. Like a sculptor holds the clay in his hands, and what you make out of that clay, and everybody has the same clay, but ask yourself why others make better, sculptures than you. The song, I like a song I like many songs, but the one that I listen to many times when I get surprised with the way people act and behave is called Truth in the World.
Truth in the World.
By Lucky Dube.
Okay.
Yes.
Okay, you're just joining us. I am pleased to inform you that you're late. We've had a fantastic conversation with Mr. Dennis Kusasira, partner at Abmac Associates and chairperson of the Judicial Affairs Committee of the Uganda Law Society. And we've been talking about building a system where cases move quickly, not carelessly, where magistrates are empowered and supported, where independence is protected, not compromised, and where justice is not the privilege of the few people, but a reality for the people of this country as was promised to them in the Constitution. We are honored that you came here, Dennis, because what you're doing, you're part of shaping a reform and carrying a profound responsibility. We work on as the parliament of the lawyers. We said we're the parliament of the bar, but we were advised that bars have many parliaments. And so we were told to call ourselves the parliament of the lawyers. And we were advised that we're the parliament of the lawyers. So as the parliament of the lawyers, we welcome you from the parliament of the country, where you took these proposals and where you asked how the courts to us to define how our courts operate, how our citizens experience the rule of law. I particularly like the suggestion that the reforms must not be a way to shed backlog of the High Court and pick the problem from one hand and dump it on the other, because at the end of the day, the citizen must be the center of justice and service delivery must be the center of it all. When the citizens walk into our courtrooms tomorrow, hopefully they will find a system that works for them because of the work that you have done and because of the effort that you have taken to make a case not just for the bar, but really a case for the public. So
I also forgot to thank you really very much for first of all putting this together. I've tried before. It's not very easy. It's not easy at all.
no, it's not.
Yeah, and it requires a lot of dedication. But it's one thing that I've always thought about. Sometimes I think about stuff like talking about our good old judges and even our judges that we have here. We come here and debate for you what is the best land transactions or land whatever judgment that you've ever read. What are the principles you deduce from it? But every time I try to, can I do this? It's quite very difficult. But I've seen the consistency that you have put in. It's quite commendable. And as Mr. Katompanga said, I think you'll be rewarded. All of us are trying to do voluntary work, but I know that the society appreciates what you're doing. That's why even when you called me on short notice, I could not turn down the invite, because I know how difficult it is to arrange these things. Thank you for inviting me. and always I'm happy to come back.
Thank you. Thank you. We shall certainly be calling you back a lot, especially since you respond on short notice. But thank you so much, really, for responding. Thank you for being here. Thank you, Mr. Mpanga, all the way from London. I take it it's London. Where?
Corby, Northamptonshire.
Corby, Northamptonshire. I said it well, I'm sure, but we go, and I never heard of that tribunal, and a special needs tribunal. So that shows the type of tribunals that are there. But if you're just joining us, listen to the recording. It's coming up soon. Over to you, Alfred.